Okay. Yes, sir.
Good morning, Your Honor.
Good morning.
Roy Fitzgerald, Manny Farad, Beal on behalf of the plaintiff.
Good morning, Judge. Nice to
Morning.
see you again. Barry Postman here live in the flesh, along with my associate Hunter Barker. We represent Brandon Jones. There's a bunch of motions. I think we're going to do in chronological order. I think that's what your prior ruling was.
All right.
That's one of the things I want to address.
Okay.
Mr. Rabin, there's a motion that deals with Ryan Marshall.
Okay.
That is still on appeal. The underlying matter is still with the fourth.
Okay.
So it doesn't make sense to hear that.
Okay.
And Mr. Rabin and I have agreed that we will just wait to the fourth rules and then we'll bring that up.
Morning, Your Honor.
Good
We want to
morning.
make our appearances as well. So Warren Johnson and I are here on behalf of non-party Pulte Group, non-party Todd Sheldon, non-party Ryan Marshall today.
All right. Welcome.
But I agree, given that particular motion is on appeal, the 40 states issued a stay, that motion is moved for at least pending decision.
Okay. Very good.
So there's now 7 motions in front of me. I understand I'm still new in this case, but you do things chronologically. There are 2 motions that overhang this case, Your Honor. One is this order to show cause motion. And the second is the revocation of Ms. Savage, who's on Zoom, and Mr. Beal's pro hoc vice. And like, I'm,
We could all get to them first. That's what you want.
Yes. Okay. Because we know it's coming January, and I got to get this case prepared for trial. And like the discovery I can deal with later, but I just need to know if I have a case or I don't have a case.
All right.
So, but I just wanted to do some housekeeping because these are very, very important motions, obviously, if Mr. Beal's case or not in the case, or if I have a case. So Mr. Postman's agreed that we can hear these 2 motions first. And if you agreed that's how I'd like to proceed.
Oh, that's fine.
Okay, thank you.
Sure.
Judge, I'll go first then. Thank you. And I apologize, Judge, for interrupting him. I was trying to make some light of the situation.
That's all
I
right.
assume Your Honor's had an opportunity, as is custom with Your Honor, to have read everything in advance.
I have read these. Yes.
Okay, so Judge, as I have indicated to you since I've gotten involved in this case, it is
Which one are we doing?
the order to show cause.
Okay.
My concern about this case has always been, it's not about what is contained in the pleadings, but about something other than that. I have suggested to the court that I think this lawsuit is perhaps a revenge by Mr. Pulte against Mr. Jones, and also collaterally, as it relates to Mr. Rabin's client, an attack on his grandfather's company in an effort for political gain. And I think the discovery of the case bears that out. So the order to show cause, I mentioned that, Judge, because I think it's relevant for Your Honor to see what has happened as it relates to this lawsuit. Your Honor issued an order prior to my firm getting involved in this case. May I approach, Judge?
Sure.
And this order was entered, for the record, on 10/12, almost a full year ago, 2023, with regard to a gag order. The gag order was necessary as a result of what Your Honor perceived, and again, I wasn't at that hearing, to be comments, social media tweets, and posts made by Mr. Pulte that concerned the possibility of threatening witnesses and having an impact with regard to the case. I think Your Honor was mindful of the First Amendment right, and there is one, but also the impact of what he might say as it relates to this particular case and the concern it might have an impact. And what Your Honor said is, with respect to witnesses, the plaintiff is prohibited from knowingly sending text, issuing tweets, and publishing posts online or on social media that, and I said could be, because I think Your Honor was giving him an understanding to be careful, right? Intimidating to witnesses and intended to cause a witness to testify in one manner or another. And I think Your Honor was weighing First Amendment and weighing my client's right to a fair and impartial trial. Again, I wasn't here, but that's what I interpreted Your Honor's
Got it.
ruling.
You pretty much got it.
I think Your Honor knows this. Mr. Pulte has a significant social media presence. I think he's got somewhere between, I've heard $2-3 million followers on social media. And I think Your Honor also knows he's a serial tweeter in terms of what he says and how he's done things.
You say, I know what I'm told in this courtroom. I'm not in
Fair
that
enough.
circle. Okay.
Fair enough. I'll represent to you as an officer of the court that to be the case. Your Honor required us to do initial disclosures. I think we agreed to them in fairness, even though it's not a federal case, to streamline the case. And within the initial disclosures, the plaintiff and defendant both did initial disclosures. And within those, I can show them to you. I don't know if I need to. Within them, the defendant listed Sharon McDonald and listed Nancy Rickard. And also, Judge, I think both parties listed my client, Brandon Jones, as a witness in the case for obvious reasons.
All right.
The plaintiff listed in their initial disclosures, Ryan Marshall, his counsel is obviously present, who's the CEO of the Pulte Group, Todd Sheldon, who's the general counsel of the Pulte Group, Stephanie Byron, again, this is on the plaintiff's disclosures, who works at the Pulte Group or did at some capacity. And I think if my handwriting is correct, Megan Hakes, who's a PR representative of the Pulte Group. The reason why I mention those names is because your order said or issued a prohibition of doing and issuing tweets that could in any way impact or threaten their ability to testify. Well, Judge, in violation of the order, and I think Your Honor has seen this in our pleadings, or hopefully in our motion, Mr. Pulte has completely disregarded what Your Honor has said. And done so, might I add, in a disgusting manner. We have given Your Honor tweets in our motion. I'm going to give you a sampling of them. Mr. Walker is going to assist me. May I approach, Judge?
Yes.
The first one, I think, is the most disgusting and perhaps representative of what has happened. This is a tweet from Mr. Pulte, or a social media post from Mr. Pulte about Sharon McDonald and making fun of her weight and addressing who she is and attacking her. And Judge, just inappropriate would be the least thing I would say. And Judge, there are multiple of them. I mean, I could go through them, and Mr. Walker's prepared to, if Your Honor didn't get a chance to read them in our response. This is a sampling of a much larger pool. And it's with regard to the people whom I represented, Judge, that were witnesses in this case, in direct violation of Your Honor's order. And I could spend the time. I don't want to spend the time. Counsel asked me, are you having an evidentiary hearing on this? Well, if Mr. Pulte is going to deny, and I don't think in their papers they have, that these are his posts, I'm happy to reset this for an evidentiary hearing and go through and confirm that he said these things. But he's specifically addressing and attacking what he has said about Sharon McDonald and Ryan Marshall. This is just disgusting behavior. I understand that we live in a free country, but when there are witnesses who are on this list, Your Honor has suggested not to do these things. On top of which, Judge, what he said about my client. And I've suggested this case is a Twitter war, right? I've suggested that.
Yeah.
These are just a sampling of the tweets and social media posts that he said about Brandon Jones.
Okay.
Judge, I'm here because Your Honor early on in this case realized there was a concern associated with this type of behavior. And I'm here because Mr. Pulte, in direct violation of Your Honor's order, has continued repeatedly. Even this past, when Mr. Fitzgerald got in the case, he said, I told my client not to continue tweeting. This past Friday, they sued my client and he issued a tweet, knock, knock, when the process server showed up at his door. Yes, it's a free country. And I'm a firm believer in the First Amendment. But when it impacts a case and it overrides the case, this is what this is about, Judge. So do I think you're going to dismiss the lawsuit as a result of his violation of the court order? I'm sensitive to the law. I'm sensitive to the finding. And I'm also sensitive to the fact, Judge, that he probably hasn't risen to the level right now of that contumacious conduct that the case law requires for dismissal. So what am I asking the court to do? First, I'm asking the court to recognize what I believe this case to be about, right? But I think that his tweets have indicated, almost making a mockery of this system in terms of the lawsuit. And second, admonishing and sanctioning the plaintiff for continuously, knowingly violating a court order and impacting this case. Your Honor, I could have Mr. Hunter go through these one by one. We've included a lot of them from what was in the motion, but otherwise I'm going to stand on Mr. Pulte's own tweets and what he's done and the mockery he's made of this court system in this particular case.
All right. Response?
Let me just start with talking to you about procedure and evidence.
I read your response.
You've not issued a show cause order. I don't know why we're here. What they've filed to you is facially infirmed. Under the Hudson case that I cited to you, you need to have a body of evidence before you. What Mr. Postman said was very eloquent, but it's not evidence. And until you issue an order to show cause, there's really nothing to hear today. What he said to you is not what they ask it in their motion. They ask for the dismissal of this case. They want you to find my client in contempt. And as I said, I don't know if they think it's direct or indirect criminal contempt because those are two different standards. They don't even tell us that. We have a whole due process problem. And to dismiss this case, and I know this court is well aware of the Cozell standards, they don't even address the Cozell standards to get the case dismissed. And now they came here and they said they want something else that's not in their motion. They want you to just hold him somehow in contempt. That's not how this works, Your Honor. They filed a motion. We're here on this motion. The motion is facially infirmed. They have not proven that even a show cause order should be issued. They've not proved any of the Cozell 6 factors. And this motion should just be denied as a matter of fact. But if you want to get into what these tweets involved, Ms. Savage will handle that. That is the exhibit to my motion. This is much ado about nothing, Your Honor. It literally is much ado about nothing. We've got to stop these side skirmishes that this case is involved in, and we just got to get this case to trial. Unless and until you issue a show cause order, there's really nothing to discuss. And on the papers in front of you, the only thing you can do under the standards set by Hudson and acknowledged by the Fourth is just to deny this motion.
For procedural reasons.
For procedural reasons.
What does that do in terms of future conduct? What kind of message is that?
It doesn't send any message, but it just like what they're complaining about. You said that Mr. Pulte can make comments relating to this litigation. That's how I read the order. And what they're complaining about is he's doing just that. And the thing about she's not a witness. And if she is a witness, then I'm sure if Mr. Farage sets her down for a deposition, they're going to file a motion protective order saying she's not a witness. So this is literally much ado about nothing. These are just sideshows. These are just distractions. That's all we're doing right now. We just got to get this case back on track. But this motion is facially infirmed, And like, the only thing you can do is deny it. I'm sorry. But that's all. If there was a legitimate motion to hold my client in contempt, like that's a whole different procedure. We would be having an evidentiary hearing. They've brought no evidence. What Mr. Postman said, as eloquently as he said it, is not evidence. And it's just argument. And you can't dismiss a case just on argument. So if they want to do it according to the procedures, let them do it. But this is just a sideshow.
Okay. Mr. Postman.
Appreciate the comment of it being eloquent, but I don't appreciate the comment of being a sideshow, Judge.
Well,
To the procedure,
yeah, okay.
I'm sensitive to the procedure, and I listen, Judge. I come in front of this court often. It looks like on many different cases, and I acknowledge that you don't have enough to do what we're asking. But I think I've presented this court and put counsel and his client on notice that he's violated a court order. And I want to try. I want to try this case. You've heard me say that I want to try this case, and I don't want there to be distractions. But I don't want Mr. Pulte to use this court or this lawsuit as a vocal point for him to exact revenge against my client and make a mockery of the court system I operate in. You could reaffirm your order and make sure he is aware that if he violates it, you could say, I don't want to have an evidentiary hearing to go through tweets, Judge. I don't want to do that. And he says Sharon McDonald's not a witness. We've put her in our disclosures, and that apparently wakened him up to say things about it. What I want is this case to proceed on its merits and the law. That's what I want. You can issue an order to show cause now and then have a violation of it. Or you could say, I have orders and I issue them for a reason. And violating them could impact you going forward. And I'm not looking, I get it. We asked for a dismissal, but I'm sensitive to the fact that I'm not really entitled to it, Judge. And I'm not going to come in here and ask for something that's going to get reversed by the 4th TCA. But if they looked at these tweets and saw the way he talks about my client and these third parties, I think they would have the same reaction a normal person would. And all I'm asking is that we stop it.
So
And-
I think we all recognize I have to deny your motion without prejudice. But in doing so, is there a way to do it so that if we have this again, I'm not dealing with procedurals and can address the merits of it?
Absolutely, Judge. And we'll put that in the order. Make sure that if you find this, because he's got to be on notice. That's the whole concept of what this case law says as it relates to the sanction. He has to be on notice that if he tweets about people that are witnesses or potential witnesses in this case and says derogatory comments about their veracity, about their weight, about their character, that's making a mockery of this system. And we'll put that in the order. And I'm sure we'll fight over it because we fight over every order, but we'll say something that it's clear that if he says things in the social media about witnesses in this case that Your Honor believes could have an impact on their ability as an objective third-party finder, gatekeeper.
All right, well, let me hear from Mr. Fitzgerald for just a second. So I'm denying the motion on the procedural reasons, Mr. Fitzgerald. What can I say in the order so that the next time we're here, we're past the procedural issues and into the merits of it?
I fully appreciate that. This is a balancing.
Mm-hmm.
It's Mr. Pulte still has First Amendment rights,
Of course.
and your order has been well received. They disagree with what he's posting. You said he could post about this lawsuit, and he believes he's just posting about the lawsuit.
This is about the lawsuit.
No, that's about his a family member who he hasn't spoken to in 20 years, who's posted about him that he responded to. So I understand that's not good. I'll be the first to admit that.
Okay.
But you know, I will accept the warts I have in this case.
All right. So
But
work with Mr.
what can we
Post.
do? Because I
Okay.
know how this court operates. What can we do? you can just tell him to follow the order that you previously entered. And if not, then sanctions may follow.
Okay,
I'm okay with that, Judge.
that's done.
I mean,
All right.
I want to make sure he's on notice. I'm
Okay.
okay with that.
All right, since, I'm gonna give these back to you since we're not doing evidence today.
Only thing I would ask is in the order, you specifically reiterate what Your Honor said in
You,
the prior order.
you go ahead.
All we need to say, Your Honor, is, and this is like, I look back on this record and it's a battle of people sending orders to you.
Yeah, I think I'm pretty clear on what I want here. And
Yeah, I got it. Your last order is to be followed. And if it's not followed, then sanctions will be instituted. Do I have that correct?
You do, and I'll
Thank you.
expect it to be an evidentiary hearing. Okay.
Okay, thank you, Your
All
Honor.
right.
Okay, Judge, this may actually lead into the last comment, on the pro hoc, this motion.
Okay.
So Judge, here's how I take it, and I may be wrong. The ability to get pro hoc in is a privilege, not a right.
Right.
And it's a discretionary one where Your Honor has the ability to either grant it, and after it's granted, to revoke it if Your Honor thinks it's appropriate or not appropriate to do so.
Right.
I talked to Mr. Fitzgerald, and by the way, Mr. Fitzgerald and Mr. Farrak are excellent lawyers. I have a great deal of respect for. And I said to him, he called me a few months ago when he got involved in the case and said, I'm going to be the new lead lawyer in this case. And I said, great, because I thought that might streamline the case and get us to where we need to be. Unfortunately, I'm not quite sure that has happened. And let me explain to you. So the law is, it's your discretion. And by the way, we didn't object to the pro hoc.
Right.
I think a lawyer that comes in pro hoc is like a guest at dinner. You have to even behave better. You know, I supervise 90 lawyers in my litigation practice here, up to 90 now, Judge. And I teach them professionalism is the most important thing you can do. Making sure that you're candid with your opposing counsel as well as with the court. That's what I try to instill in the lawyers that work for me. And if they don't do it, I've had judges call me and I admonish them. If you're going to appear in someone else's house for dinner, you read the rules. You make sure you follow the level of professionalism and you act not just as other lawyers would, but perhaps even better because you're a guest in their house. And I'm apologize for saying this, but that's not what's happened in this case. We can't agree to an order. We can't agree to a schedule. We can't even agree to handle each other with a level of professionalism, not with regard to Mr. Fitzgerald and not with regard to Mr. Farrak or their law firm. Not. And let me give you the examples. And I cited them in the motion. Something was contained in a motion and we're going to refer you, my client, they wrote it, my client's going to file an ethics complaint against you. I know this, that in itself is a bar violation, right? You can't threaten a bar violation, particularly with regard to getting an advantage in a case.
Just gotta
Second,
do it.
you can't
Okay.
do it.
Yeah.
Second, it clearly informed me about filing the show cause motion saying it wasn't subject to the litigation privilege. Well, the only way a lawyer would read that is I'm going to get sued with regard to filings in this case. Judge, you don't do that. Third, there was an inadvertent disclosure that we unfortunately did with regard to a privilege log. There's a procedure we follow. Mr. Farrak knows it. Mr. Fitzgerald knows it. That's how lawyers in this community operate. We act like professionals. We fight, but we fight by the rules and with appropriate demeanor and professionalism, not disclose it and say you were wrong to claim this is privileged. You ultimately upheld the privilege.
Yeah.
Judge, when Mr. Fitzgerald got involved in this case, right afterwards, the plaintiff was supposed to be deposed. He called me and said, Barry, I'm involved in this case. I need to go on a vacation. I have a trial. Could push off the depot. My client wants this depot. Okay, we still don't have the depot. I said, Mr. Fitzgerald, if you need the courtesy, of course, I'm going to give it to you because that's what lawyers do. That's how we treat each other in this community, hopefully in front of you. And if we don't, that's how we should. And lawyers of our age group should be examples for the younger lawyers. Yes, we fight. Yes, but we fight by the rules. That's how Mr. Rabin operates. That's how his partner operates. I'm hoping that's how he's going to operate because I train him to do so, Judge. I was told I had a problem for tomorrow's depot. So I called Mr. Fitzgerald, right? And now you can only push it off if you withdraw a motion. That's not how you operate, Judge. We can't even get our hearings heard because they won't agree on dates. So let me go back to the ask. I would love it if we designated, by the way, there are a lot of lawyers in this case, a lot. And I think there's a right, you can choose the lawyer. I would like Mr. Fitzgerald or Mr. Farrar to sign every pleading, every motion, because they know the rules and they know how to operate. I would like them to, one of them or both of them, or some of them need to be at every event in the case. I don't have to take the depots, but they need to be there because they can educate them on how we treat each other. That's the ask. Do I have enough to stop them? Judge, I want to make sure Your Honor is aware of this conduct because this case has gotten off the rails. We haven't even gotten depots done in this case yet. We haven't started yet. Tomorrow is the first depot. And I'm worried that you have a trial date in January. If you remember, I asked for this depot eons ago, the wife's depot. That's an example of the kind of thing. I asked for their wife's depot. The response, I think we're in front of it. I said, if you drop the claim for personal injuries, I don't want to take his wife's depot, and you drop the cyber stalking because you've claimed that she was harassed by this, I don't need to take her depot. You know what the response was? They want to take my client's wife's depot. And that's also set for today. So this is not how we operate here. I welcome Mr. Fitzgerald and Mr. Farrar, but I think it's appropriate for Your Honor to require them to be more involved with regard to the signing. That's the ask, Judge.
Okay. Response?
I'm not really sure what I'm responding to. The motion just seemed to have morphed into something else. They were asking you to revoke the Pro Hoc Vice admission of Mr. Beal and Ms. Savage. And now he's just told the court what he wants is something very different. So let me just, for the record, Your Honor, address the revocation of Pro Hoc Vice admissions. The standard is that these people have adversely impacted the administration of justice in this courtroom. And there's nobody sitting in that box right now telling you how that happened. And again, I don't mean to harp on something that's true and dear to my heart, procedure and evidence. But I will. And if you look at the State Industrial Inc. case that's cited in their materials, that sets forth this very, very high standard. It's an incredibly high standard. And they have to prove to you that there's been some impact on the administration of justice.
Right.
And again, this is probably the last time I can tell you this, that I'm new in this case, because I'm now getting up to speed. But I see nothing, and they've presented no evidence that this has happened. So,
Well, they haven't presented any evidence.
well, I called, like,
What about threatening ethical violations and grievances and things?
that's not what happened at all, Your Honor. He simply wrote him and said, if you look at the letter that's attached to their motion, that you made a misstatement to the court, please correct it. If you don't, my client may go to the bar. He didn't say he was going to the bar. He didn't say anything to the sort that was just represented to you. And I want to just take a brief exit. Like, I called Mr. Postman last night, and we talked at 7:30, 8 o'clock. What time did we talk? Like, yeah, and like, I do things much differently. I just pick up the phone. I call Rabin all the time. I call Mr. Rabin all the time. I call Mr. Postman all the time. Mr. Beal is a chosen lawyer for Mr. Pulte. Yes, Mr. Farach and I have come in and we're doing a lot more in this case. But without evidence before you again, and I hate to just keep harping.
No, it's true.
There's no way that you can.
There is no evidence.
That somehow they adversely impacted the administration of justice that will uphold. And I will do all I can with Mr. Farage to get this case back on track. And we got to stop this. I've told everybody, stop the adjectives, stop the adverbs. That's not how I write. And it's just, we've got to get this case to a place where we're like, we know how to try cases.
Okay,
Eh,
so let's get to other stuff. The motion's denied without prejudice. I hope that this will be the end of these discussions. But if it happens again, we'll have an evidentiary hearing. And
From your lips, Scott.
we'll address it appropriately in the courtroom. I've seen nothing but professional behavior from counsel, but I know things happen sometimes. I'm not saying they did. We have no evidence in front of us, so I've seen nothing but professional behavior here in the courtroom.
Thank you, Your Honor.
The purpose of these motions is to get it back.
I understand. I'm kind of hearing warning shots. Maybe call them, here's a preview. Please let's not go forward and have it. That's fine. That's okay.
I've been around the block.
Yeah.
I agree. And I know
Okay.
that's a compliment. I don't know, but I intended to be so. How about the motion for protective order with regard to my client's wife? You hear that one next?
That's not me. That's.
Yeah.
Okay.
Yes. Okay.
The guy who still has pro hockey.
Indeed he does.
So
Okay.
Judge, only because I mentioned it earlier, let me just refresh Your Honor's recollection, because I think it happened in front of you. You talked about trying to compel the address to take the wife's deposition, and Your Honor said, work with them, which is
Right.
what lawyers should do. The response was,
They need help from their client. Okay. You know that.
I'm not, but that's not what we're here for. My point is I'm refreshing Your Honor's recollection as to how this all born about, and that's what happened. The response, as opposed to helping us with that, Judge, was to request my client's wife's deposition. Judge, there is a relevance to the plaintiff and the plaintiff's wife if they're making the cyber stalking claim and they're claiming personal injuries. I'm hoping to leave her out of it because I don't think she should have a place, but if they're not dropping those claims, she is a material witness as it relates to that. And the response was, okay, then we want your client's wife's deposition. He is the defendant in the case. He's not making an affirmative claim. She has filed an affidavit. I don't know if Your Honor saw it, attached to the deposition, attached to the motion, confirming that she has no knowledge. They've not articulated any basis or reason. My client's not even denied that he made the tweets. Okay? What information she would have is not relevant. And by the way, there is also a husband and wife privilege in Florida to the extent he said something to her. The only reason this deposition is being asked for, and they're proceeding with this, is to have me drop taking their client's wife's deposition or as an abusive tactic with regard to litigation advantage. Completely inappropriate. Judge, we'd ask that the motion for protective order with regard to the wife be granted. If they come back in front of the court at some later date with a basis, I'm happy to re-entertain it. I'm not saying it shouldn't be granted without prejudice for them to come back, but it should be granted, and we should proceed to get to this case and not take depositions or seek them for purposes of revenge or litigation advantage.
Okay. Morning.
Good morning, Your Honor. It's hard to sit there and bite your tongue, but
You did well.
I will sit there and bite my tongue.
Okay.
Don't receive our lack of any substantive response as acquiescence. Obviously,
Professionalism.
yes, thank you very much. We understand there are marital privilege issues. We filed a motion for protective order to prevent Mrs. Pulte's deposition under the Florida marital privilege. Ms. Jones is in Georgia. There's no law or evidence before you as to the application of the marital privilege in Georgia. So why did we notice Ms. Jones' deposition? They argue it was retaliatory. In fact, Brandon Jones testified in his jurisdictional depositions that the tweets that we allege are defamatory were made not using Pulte Group servers, but made while he was at home and not during business hours. He testified to that under oath. We noticed Ms. Jones' depositions to question her about that because we think it's relevant for two reasons. If she doesn't corroborate that he was doing the tweeting at home, that calls into question Mr. Jones' credibility, which is always relevant in a case. And secondly, if he wasn't tweeting while at home and was tweeting during business hours, and we have some evidence that he utilized Pulte Group servers, that is relevant to what discovery we're entitled from Pulte Group. So in support of the motion for protective order, Brandon Jones submitted an affidavit from Mrs. Jones saying that she didn't know he had a Twitter account and she had no knowledge of his tweeting activity at home. And I will just say, if that's received as evidence under oath, we're willing to live with that, with the understanding that we may be seeking further discovery from Pulte Group based on that evidence. And I would just say that I've already talked about the marital privilege. I don't think it's implicated here because the intent was to ask her what she saw him doing, not based on communications between the two. We think what she saw him doing, the record will show his tweeting activity was a lot over this period of time. And again, I'm not here to comment on the credibility of the affidavit or not. Everybody's marriage is different, right? So, but when she says she didn't even know he had a Twitter account, I have to accept that at face value. She signed something under oath, but it certainly calls into question whether he did all this from home. So that's where I am on it. That's where we wanted to take the deposition for that reason, not for retaliation, not to invade any marital privilege. We think her testimony would be highly relevant. And apparently Mr. Postman's not willing, and we're not here to argue any motion for protective order on Mrs. Pulte. If there is a marital privilege, it applies both ways. Mrs. Pulte submitted an affidavit saying anything she knows is based on communication with her husband. So I think prudentially, if we're not going to go forward with Mrs. Jones' deposition, we're not permitted to, then at least for now, I think both spouses should be, there should be no deposition, but I understand Mr. Postman may want to argue that.
So, with respect to Mrs. Jones, do you, you're looking for a stipulation to what effect?
Well, she submitted an affidavit saying, I didn't.
I have the affidavit. But
Yeah.
what would the stipulation be aside from the affidavit?
That, I think if the affidavit is received as if they want to stipulate to it, what's in the affidavit, that she didn't know he had a Twitter account. She didn't see him doing any tweets from home. I think we're fine with that. We don't need a deposition.
Judge, it's just one affidavit. Yeah, I agree.
Well, but
I'll stipulate to it. Is that what you're asking? I agree.
Okay.
But I mean, I just don't take the jaws of victory for defeat, but the whole purpose of wanting her depo was the last part, trying to prevent me from taking a witness depo in the case, and we'll address it at a later date. But I just want to make sure that was noted, but I'll take the stipulation, and I assume with the stipulation, the motion for protective order is granted, is that fair?
You gave the stipulation,
I did.
and yes, the motion is granted with the stipulation. Okay. What's next?
Your Honor, can we do the motion to remove the confidentiality designation of Jones's deposition transcript?
Mr. Postman?
It's fine, that's Judge.
Okay.
Cooperate, that's okay.
All right, that's fine. Ms. Savage, go ahead.
Okay. Thank you, Your Honor. So I want to just kind of remind you of where we were previously here. So we've been here on this issue of the designation of Jones's deposition before. What happened is that Jones had previously just done a blanket designation on the deposition transcript. But at the July 11th hearing, you made it very clear that that was not acceptable and ordered Jones to identify by page and line the parts of his deposition transcript that actually are confidential under the terms of the confidentiality order. You did not, in that hearing, permit anyone else to designate portions of his testimony as confidential. And you warned that improper designations may lead to a loss of the ability to designate. So about 20 days later, at the end of July, we received designations of the deposition transcript. In addition to Jones sending some designations, actually most of them were sent by Pulte Group. And all of those Pulte Group designations are improper because it's a third party who has no right to designate the testimony of Jones. Additionally, all of the designations, whether by Jones or by Pulte Group, do not fall under any of the categories of confidential information under the confidentiality order. So we were very specific in the confidentiality order of what is confidential and what's not. And there's quite a list. I'm happy to pull up the order, but they're very specific, and they were, given the nature of this case, targeted in addition to kind of your normal stuff like personal identifying and financial information. There was kind of a sensitivity toward, there's some housing issues. There's Pulte Group was a party to the confidentiality order. So kind of with an eye toward like what's the Coca-Cola recipe equivalent for the housing industry, right? Unfortunately, despite having taken all of those efforts to agree upon what is confidential and what is not confidential, Jones and Pulte Group have just continued to overmark everything. We've got a lot more coming down the pipeline on this, unfortunately, because it just consistently happens to try to over-designate anything. And so I'm happy to just march through each of the designations if that seems like a proper way of handling this.
Let's see if it's necessary. Yes, sir.
So, I mean, we marked, when we were here last time in August, you directed us to mark things confidential on depositions that plaintiff previously agreed to treat in the entirety as confidential. So we did that. We went line by line. And in total, for both depositions, several hours of testimony, we marked 11 things confidential in total. These are things like where my clients' children go to school, where they play tennis, things of that nature. So I'm not sure, she's stated that we improperly marked things confidential, but if you read their motion, they don't point to a single designation. They take issue with Pulte Group's designations, I suppose. But nothing in your order precluded Pulte Group's confidentiality or their right interest in that. What your order directed us to do was mark things line by line on depositions that were previously entirely treated confidential, and we did that. And nothing in there precludes Pulte Group's confidentiality, which I'm sure they'll argue here today.
Well, let's start with your clients. So with respect to the Jones designations, is there something you take issue with, Ms. Savage?
Well, they all just categorically do not fit within any of those. So we have, on pages.
You're challenging the designation of where their kids go to school?
Well, I mean, there are a variety of things on the family calendar. And I mean, we're happy to leave those as they are, but subject to, we don't want that to be conceived as like a waiver of that right, because there's a lot of misuse here. And, we're not trying to make it public where Mr. Jones's kids go to school at all, but we do want to be consistent. We don't want it to seem like we're okay sometimes if you make up a category of confidential information, but other times you're not. So as long as that understanding is made, then we're fine with withdrawing our objection to the family calendar stuff.
Your Honor, if I just may briefly. So there is a provision in the order providing for confidential information of personally identifying information.
I don't really think I need to hear anything on it.
Okay.
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 So the personal family information is properly designated as confidential. Okay.
Okay. I think the only one that doesn't fall within that kind of category that it was designated by Jones is there's some designations about his IP addresses, which we were going through his debit or his phone records, and they had IP addresses. I don't see how those are confidential.
All right.
Yeah, again, I mean, it's personally identifying information. If someone has his IP address, someone could remotely hack our individual's phone. I mean, this thing, any in discovery or testimony that we produce, we have the understanding that there's a good chance it'll end up online. And something like an IP address, I mean, you can get remote access to our client's device, things
So
of that
by
nature.
designated as confidential, they can still use it for purposes of discovery. They just can't publish the information.
Yes, Your Honor.
Okay. What do you want to do with it, Ms. Savage?
I haven't heard that argument before that an IP address can be used to hack his information. If that's true, that's certainly a different analysis. And I would agree that.
How are you being restricted from discovering the case?
Well, it's not that we're being restricted from receiving the information. It's a lot of the restrictions on what we're able to do with the information. So for example, with everything being designated confidential, every time we need to submit something to Your Honor, we have to file it under seal. We have to do a notice of it, and we have to redact certain portions of it. And it's a lot of like side busy work. And again, if there is a Coca-Cola recipe or personal identifying information, we're happy to do that. We have also used this appropriately to designate certain things as, like financial information or whatever, as confidential. So we understand, we believe it can be used properly, but here it's not being used properly. It's constantly being applied to everything. I mean, there's certain things that are like, there's this idea that all text messages are just inherently confidential, even if they don't talk about anything that's confidential. And so it's just this gross misuse of it.
Okay. So
If I may just comment
Yeah,
on
go
that.
ahead.
I mean, I don't know if she's referring to old discovery, but anything we've produced since we've come on, I mean, it falls squarely within the definition. We haven't been marking text messages confidential just because they're text messages. I believe, this is plaintiff's now fourth attempt at removing our client's right confidentiality in this case. And I think, instead of conferring with us on these designations, which the confidentiality order requires, they've filed this motion on designations pertaining to my client's family, one IP address, I suppose.
okay.
Well, Your Honor, if I could just kind of streamline this one with Jones, I'll accept Hunter's representation about IP addresses, and we will withdraw that along with the calendar entries. Jones's designations were the least concerning. Pulte Group's designations are certainly more
get to-
extensive and more concerning.
There you go.
I'm not, by the way, I'm not a huge tech guy, but I do believe, and I think, maybe someone else can confirm this. If you have a device's IP address, you can use that to access that device. That's my understanding.
You're looking at the wrong guy.
That was our reasoning behind it.
Okay, well, all right. So as to, Mr. Jones, I guess it's an objection to the designation of confidentiality. They're overruled. Ms. Johnson?
Thank you, Judge. First off, procedurally, as Mr. Walker noted, there was no conferral, from plaintiff prior to filing this motion.
What is the standing of Pulte Group to raise these issues?
The confidentiality order specifically provides for the ability of a non-party to make designations of confidentiality. Pulte Group engaged in extensive negotiations with plaintiff's counsel to come to the terms of the confidentiality order. And it did end up being an agreed amended confidentiality order. So we participated in the drafting of it, and it does explicitly provide for a non-party such as Pulte Group to make the designations.
Okay. So you want to confer?
So plaintiff did not attempt to confer before filing. We did end up reaching out to plaintiff's counsel to confer. We'd remove some of the designations that we had on the deposition. We made the designations within 1 day of receiving the transcript. And we did remove a few, like I said, but plaintiff's counsel refused to resolve the motion unless all the designations were removed. And on the substance of the designations, the testimony at issue relates to Pulte Group's non-public commercial information. Mr. Jones testified to things like Pulte Group's market areas, their organizational structure, the chain of command, who reports to who. He even testified about profitability, what market area is the most profitable, things like that. That is non-public commercial information. And those are the designations that we made under the confidentiality order. And this deposition was a jurisdictional deposition of defendant. It was taken back in September 2023, over a year ago. These issues have no bearing on the issues in the case. Your Honor already ruled on the personal jurisdiction of defendant, so there's nothing relevant in this information that will be used in the case going forward, and there's nothing that has had to be used in filings that have been made in the case. So, we have Pulte Group has a concern of use of this information outside the case for improper purposes, and we just want to make sure that that doesn't happen.
Understood, but I guess the question they're raising is whether the confidentiality designation is being used for purposes of restricting publication of the information when it may not in fact be confidential. Do you want to comment on that?
Sure. It is non-public information. Like I said, Mr. Jones testified to the most profitable area of Pulte Group. That's not public information. He testified to the chain of command, the structure of who reports to who in certain areas. He testified to certain business travel and board meetings that Pulte Group has. So it's non-public commercial information.
Okay. Ms. Savage?
Your Honor, there is one brief mention in the many designations about the which market is the most profitable was being discussed. Fine. Well, we can accept that as non-public commercial information, but the rest of it is very much not. So we've got testimony on 36 and 37 about Jones taking a private jet to a Pulte Group meeting. I don't know how taking a private jet somewhere is itself confidential. There's also, and I'm happy to go through and show the specific testimony if you'd like to see that.
What I want you to do I have the designations you're taking issue with?
Yes, Your Honor. They are attached to our motion. I think it's Exhibit B and C are the two deposition transcripts.
Okay.
And so Pulte Group's designations are in green. So I guess that's still what's at issue. They have removed some of those. Would you like us to like,
I want you-
resubmit those?
I do. I want you to resubmit them. I'm going to go through them and I'll rule on them.
Okay, so we will resubmit the ones that are issue. And
Yeah, I
for you to
haven't,
do
I
it.
haven't looked at the individual entries that you're referring to. I think it would be appropriate for me to do that.
Okay,
I feel like I'm
um,
to do otherwise. I just ruling in the abstract, and that's not what I want to do.
okay, we are happy to do that.
Okay, sooner, if you get it to me sooner rather than later, I'd appreciate it. Ms.
Okay.
Johnson, anything else?
No, Your Honor.
Okay. All right. Is there anything else for this morning? I don't have any time left, but well, if it's really quick.
Yeah.
Did you have something you did? I
accept that other than face and take too long.
Yeah, I was gonna say, I got time this week, just call Lucille and we could do it, but you know, I don't know what's gonna happen with this hurricane. I'm not quite sure.
Or tomorrow?
Yeah, tomorrow, but I'm not sure about Wednesday or Thursday. I just don't know yet.
We have a depot set tomorrow.
I think you're okay,
Hey,
there.
one
everything-
thing, Your Honor, that may just be a brief mention is we also have a motion to challenge the designations of Stephanie Byron. Would it maybe make sense to follow the same approach?
Yeah, same approach would be great. Yeah, it'd be great.
Okay. And would you like these emailed to you or hand delivered?
Email's fine, just don't file them. I know you got some issues with that, so don't do that.
Your Honor, Ms. Bourget will.
Okay, that's fine. Thank you, Mr. Fitzgerald.
We'll do orders, Judge, and thank you for your time. And we'll check with the court. Hopefully everyone is safe and see if we can get some hearing time.
Yeah, I'm happy to do it. I'd love to get these things out of the way so you guys can move forward and prepare for trial.
Okay, thank you, Judge. I appreciate you.
Your Honor, I just had one thing, with respect to Ms. Byron. She has separate counsel. I'm not sure he was given notice today
Okay,
for this, so I just want to make sure that the plaintiff, when they set these hearings, that they give any non-party that has an interest issue notice that they can attend.
Your Honor, can we just get an order in this case that just tells people to pick up the phone?
why don't you, everybody,
I guess I'm the old, I'm the old
everybody-
grouchy guy now.
A lot of-
Your Honor, but
no.
just pick up the phone.
everybody seems to be harping from the same, what is it, the same song. So why don't you guys put together an order? I'd love to sign that. Okay,
I will.
would you?
I will.
Okay. All right.
That nothing can come before you unless people have, not just.
Gotta
email,
talk.
that-
Gotta
that
talk.
They speak to each other and they
Yeah,
try to
don't-
work it out.
Yeah, don't, except maybe an emergency or something.
I
Okay,
understand.
okay. All
Thank
right,
you,
you
Your Honor.
guys be safe. Hopefully. we'll
Thank you.
be spared.
Thank you, Your Honor.
Yeah, no problem. Take care, guys.
Be safe.
You too. How are you?
Yeah, how are you?
Doing okay.
All right.
Yeah, everything's good. You have a good weekend?
I watched.
Stupid dogs don't know how to, they should just, let's just email me. We'll go for the number one. Instead they win when you.
Yeah.
Do you?
Yes.
So. Outside of the game. I see the team.
That pass.